Appeal number 34, the people of the state of New York versus Teri W.
Good afternoon, Your Honors.
Good afternoon, counsel.
Lawrence Houseman for the defendant appellant, Teri W., and I would like to reserve 2 minutes.
Of course.
Thank you. So the question on this appeal is the period of probation for a youthful offender whose substituted conviction was for a sex offense. And it's, as Your Honors are aware, it's Penal Law 6002 that governs youthful offender sentences.
So we have Torres, we have Gray, and we have Brandon T. So that's the second, third, and
Fourth.
Fourth,
First, second, and third.
first, second, and third department. They all agree. So what are we doing here?
Well, Your Honor, respectfully, they got it wrong.
But the fourth department, if they ever got there, they might have gotten it right.
Well, I expect they would have.
So, is there anything in the language of the statute itself that says that we should do the analysis that you say we should do?
I think there is, Your Honor, and I think Your Honor's decision, I think, in Jorge D., although ultimately it disagrees on this piece of it in dicta, I think Your Honor's analysis in Jorge D. gets us a long way there.
Right, but in Jorge D., there was actually a statute that indicated that a prison term could only be a determinative term, right? And so that's really what we rested that decision on.
But I think if you step back a little bit and you look at 6002 together with 72020, what Jorge D., I think, recognizes is that you have this term in 6002, Class E felony offense. And the question is, do you mean like a regular Class E felony as opposed to a violent E felony or drug E felony or sex E felony, or do you mean any E felony? And I think what 7220 does, it says that language, Class E felony, 72020 means it means that it's that regular E felony, the indeterminate E felony,
well,
right?
Well, I know, but as I say, there was another statute that seemed to contradict that. And so is there anything here that contradicts that other than, well, I don't know.
Well,
is there anything in the statutory?
But I don't think that 72020 contradicted anything. I think it informed the definition of Class E felony. And I think Your Honor made the point in Jorge D. that when this all started, when 6002 was enacted, there was only one scheme. There was what I'll call a regular E felonies. There were no violence determinants, there were no drug determinants, no sex determinants. So clearly at its origin, when the legislature said E felony in 6002, they meant indeterminate terms with maximum of 5 years probation.
Does that mean that in every case we have to go, in order to interpret the statute, we have to go back to the very beginning of time when that statute was originally enacted, or can't we assume that the legislature knows about Torres and Gray and Brandon T. and how this is being implemented, and if the courts were getting it wrong, they could do something about it?
Well, an important point on that is that the legislature rarely intervenes over intermediate appellate authority. So the cases like State Farms and Palladino are cases where this court is considering rethinking an earlier precedent of its own. So the cases where the legislature has been deemed to have withheld acting in light of intermediate appellate authority is when there was a special call for the legislature to overrule some lower intermediate appellate courts, and they've refrained from doing so.
So let me ask you this. If the legislature, instead of doing what it did, had increased the penalty for E felonies, you would agree, at least in that circumstance, that increased penalty would apply, or increased probation, let's say? For all, it didn't classify them, didn't have a special carve-out for sex offenders, just said...
Yes, then absolutely I would agree.
Okay.
And so I think this is a two-step analysis here, which is, first, what did the legislature mean by Class E felony? And like I think Jorge D. does a nice example, there's 3 reasons why a Class E felony meant a non-drug, non-sex, non-violent felony, and that's 1, because that's how it was at the beginning, and 2, when the legislature started to add all these other kinds of schemes, they didn't do what you would expect them to have done, and what they did in other similar language in the statute. They didn't say an E felony of the type that's being substituted. And in fact, when this very statute has made some other exceptions, they've said things like, for example, conditional discharges and unconditional discharges can apply to certain drug sentences. And they say, except when the substituted conviction is X, Y, and Z. And so you would expect that when the legislature...
But it also didn't say to an undesignated or unclassified or whatever e-felony. And so when it refers you to the term that's permitted for an e-felony, don't you have to then go to that statute and say, okay, what's permitted for an e-felony and what are we dealing with here?
Well, one important point is that the legislature doesn't really use the term undesignated or unclassified, and so when they say
they could use language of that sort.
They could, but throughout, even in the penal law, like Penal Law 70, when they're talking about non-drug, non-violent, non-sex felonies, they say an e-felony, and so I think you're right. In certain circumstances, maybe an e-felony could mean all types of felonies. But that's why you have to look at the context, which is...
Well, talking about context, let me ask you one other question. If we agree with your interpretation, then don't we have this kind of strange result that a class, somebody who is a youthful offender having been convicted of a Class A misdemeanor sex offense gets a longer term of probation available than a felony sex offense?
Assuming you agree with the people's interpretation of that misdemeanor statute, and I think that you could easily also just say that in 2000, when the legislature expanded these probationary terms, they weren't thinking about the youthful offender sentence. And I think the best evidence of that is that although 6002 had clearly only referred to regular e-felonies, the language didn't at all, they didn't introduce any language that tracked that e-felony, which as we know was already completely separated from the level of the substitute conviction, right? Even if you have a B conviction, you're getting an E, but they didn't do anything to connect it back to the type of underlying
So, Mr.
crime.
Hausman, come along to CPL 65.
Yes, Your Honor.
Probation statute that requires the court to consider the nature and circumstances of the crime, the sentencing court. So doesn't that lead us directly back to the underlying offense here and the nature of that offense?
The reason I think it doesn't is because if you
Does
start
not?
at the very section of Penal Law 65 where it talks about criteria, it talks about convictions. And so then later when in Section 3 they talk about a felony sexual assault, I think clearly they're talking about a felony sexual assault conviction, whereas...
Was there no regard for, I get the conviction piece,
Right.
for the underlying offense and the facts and circumstances surrounding that?
Well, Your Honor, I think...
And the purpose of the
You're absolutely
probation?
right that you would look to the underlying circumstances in fixing the appropriate term of probation within the legal... once you decide what that term is and in deciding whether to impose probation or not. But in answering the legal question of whether it's a 5-year term of probation or a 10-year term of probation, you have to go back to that question of when the legislature said a Class E felony, did they mean a Class E nonviolent, non-drug, non-sex felony, or did they mean one that just... Or did they mean, well, it depends, but we're not telling you when each section applies. I mean, an important point is that when the legislature, can I just finish my, I'm sorry,
Yes,
see
you
my time's
may.
up. When the legislature started adding enlarging the probationary terms in 2000, they didn't change the language in 6002, but so for the people's position to be right, that same language in 6002, a Class E felony, would have to, under Jorge D., mean a regular Class E felony, not a drug E felony or sex E felony, but for probationary sentences, that very same language, which they didn't even change, would all of a sudden have to also mean, the opposite, and would have to mean a sentence based on the underlying conviction. And I think Penal Law 65 doesn't support that because it's limited to, when it talks about felony sexual assaults, it has to be referenced back to the criteria section, which deals with convictions.
Thank you,
Thank you.
counsel. Counsel?
Chief Judge, and may it please the Court, Lee Pollack for the people. The legislative scheme at issue in this case is entirely internally consistent because 6500 particularly subsection 3D, second last paragraph, explicitly keys the enhanced probationary sentence for a sexual assault, for a sexual assailant to the offense, whereas all of the legislation, all the provisions that we're discussing regarding incarceration are keyed to someone convicted. And while 60.02 does state that a youthful offender conviction substitutes for the conviction, the adjudication substitutes for the felony of conviction, it still clearly and explicitly contemplates that a youthful offender has committed a cognizable offense. And so the only way to read these two statutes together is that when, as in this case, the youthful offender has committed the offense that is a sexual assault, the separate and wholly independent definition of that term that appears only in 6500, and it says in this section this term means an offense, that the only permitted sentence at that point is the 10-year sentence of probation for people who have committed that offense.
Do you know of anything in the legislative history that suggests that when the legislature increased the probationary period for sex offenders, it was thinking about the interplay with the youthful offender statute?
There's nothing in the explicit legislative history, but we do have this decade of silence in response to consistent appellate division precedent interpreting these statutes in this way, despite the fact that there have been multiple amendments to each and every one of these provisions in the last 10 years, but nothing that changed the outcome in Gray, in Torres, in Brandon T. And so, and the other critical piece of information, I think, is that the statutes here on their plain language fit together correctly. They lead to exactly the result we're talking about, exactly the result that the appellate divisions have repeatedly come to, that for sentences of incarceration, which are keyed to conviction, a youthful offender doesn't have one. For sentences of probation, which are keyed to the offense, the youthful offender absolutely has one. And it even makes sense that would be where the legislature would come out, because the whole point of the youthful offender scheme, repeatedly throughout all the evidence, is to avoid the stigma of incarceration. Sexual offenders don't end up registering under SORA. It's all about avoiding stigma, but that's different. And in fact, 65 explains that the purpose of probation is different. It's not stigmatizing. Probationers are not registered in a public, you can't look them up online. The purpose of probation is where the defendant is in need of guidance, training, or other assistance, which in this case can be effectively administered through probation. The point of probation is to help people get back on the straight and narrow and stay on the straight and narrow.
Being on probation can be stigmatizing. The question here is how much time you spend on probation.
But I think that there's a critical issue where probation it's not punitive. It's rehabilitative. And these individuals, the legislature quite reasonably determined, sexual offenders, people who've committed these sexual assault offenses, benefit from additional
Then wouldn't one expect to find language in the statute?
I don't think
so. That we wouldn't be here today?
I don't think so. I don't think the legislature needed to amend the statute, needed to amend 6002 when on its terms, when read in conjunction with 6500, it gave the right answer, and when read in conjunction with 7080, on the incarceratory side, when read with 7070 and 7071 on the drug side, it also gave the right answer. There's no reason for the legislature to engage in additional amendment, to expect them to engage in additional amendment, when on a close reading of the plain language of the statute, you get the answer they clearly wanted and the one they have ratified by their silence. I do want to briefly, if I have a moment, speak to one issue that my opponent raised in his reply brief and I haven't had a chance to speak to before, which is this notion that you end up with a strange result under 65(3)A Romanet 2, which is the provision about A1 drug and B second felony offenders.
You're talking about the argument that's made against them is that an A misdemeanor would be 6 years probation, where unclassified E would be 5, and then the response would be, but look at felonies. Is that what you're talking about?
No. So on the last page of my opponent's reply brief, he makes an argument that the plain language reading can't be correct because there is this additional provision regarding felony probationary sentences for B second felony sex offenders and A2 drug offenders,
right?
Which lead to 25 years or lifetime probation. And
okay, all
the
right.
response, which we haven't had a chance to give yet because it was in our opponent's reply brief, is that actually a youthful offender can't fall under either of those provisions. A youthful offender can't be adjudicated a second felony offender by definition. They don't have a conviction. And 7071, which is the statute that's explicitly referenced in, and this is 65003A Romanet 2, explicitly references a felony drug offender as defined in subdivision 7071. That provision also requires a person to stand convicted of a felony, which we absolutely agree with defendant. Youthful offenders don't stand convicted of a felony. And so again, the statutes fit together absolutely seamlessly. No additional amendment was required. If the panel has no further questions, we ask that you affirm.
Thank you, counsel. Counsel, Mr. Hausman?
Yes, Your Honor, thank you. Just going back to Penal Law 65, which I think is where a lot of the discussion is focusing. I think if you go back to 2000, when the legislature was looking at Penal Law 65 and saying we're going to increase the adult probationary terms 10 years and 5 years, I think it's pretty remarkable to think that this legislature, already knowing that language E felony from 7/2020 was referring to regular E felony sentences, that they would, if they thought, oh, let's raise it for youthful offenders, will nonetheless leave the youthful offender statute alone. And we also won't mention the word youthful offender in Penal Law 65. That's a pretty remarkable thing for them to do, to change the youthful offender sentences by both leaving the youthful offender statute unchanged and by being silent about the term youthful offender in Penal Law 65. And then if you also think about the fact, that that term felony sexual assault in Penal Law 65, as I said, is really defined by Section 1 criteria, which talks about convictions. And it's often the case in other similar statutes. For example, in 7080, this first section talks about felony sexual convictions, right? And then later on, when it says the length of sentence for those convictions, it starts referring to them as felony sexual offenses, and it drops out the word conviction. So clearly, once you know you're talking about conviction, which you do in Penal Law 65, once you're talking about the criteria, the fact that you don't continue to repeat the word conviction is of no moment, nonetheless, because that felony sexual assault refers back to that term conviction. So what you have here is you have what I think is an implausible supposition that the legislature in 2000 is changing the probationary term adult felony convictions, and then let's suppose some legislator says, all right, let's change the youthful offender sentences too. But then they don't go to the either 6002, which they know has, by their other statute, 70-2020, really limits E felonies to non-sex, non-drug, non-violent felonies, right? So they know that. And they know really that felony sexual assault is defined by the term conviction, and yet they don't say anything about youthful offenders in Penal Law 65, and they don't make any change to 6002. I think that's a remarkable inference to draw from the circumstances. And I think, and again, just to emphasize one other point that I made earlier, which is I think that the legislature's failure to act in response to intermediate appellate authority is really of no moment, because the authority that's relied on by my adversary on that point is either the Court of Appeals saying, yeah, we're not going to overdo our own prior precedent because the legislature is aware of it, or cases where there was some intermediate appellate authority, and then there was a specific call to action for the legislature to act in response to those cases, and the legislature chose not to. Because otherwise, I think it's fairly typical for, when the legislature, to the extent it's conscious of intermediate appellate authority, will often wait till it percolates to this court before it takes any
So your answer to Judge Feynman's question about why we're here is so that we can issue a ruling that the legislature can then reverse.
Right, and I hope that and hopefully they won't reverse it, because hopefully you'll agree that if they had meant to do what the people suggest they meant to do, they would have done something to either Penal Law 6002 or to Penal Law 65 to give some hint that that's what they meant to do when they enhanced the probationary terms for adult felony convictions.
Thank you, counsel.
Thank you, Your Honor.